So good morning, and thanks for coming today. As Doug mentioned, my name is Craig Dean. I'm the Chief Technology Officer for a law firm, Orrick, here in Kentucky. I've been with the firm for about 4 years, and it seems like for those 4 years we've been talking about the cloud as one of our top priorities and trying to figure out how to best leverage it to do a number of things. And so I'd like to just today walk you through kind of our experience, some of the compliance challenges that we faced, and also a case study of something we just went through, and how kind of contract negotiations and what we did and didn't do well in those contract negotiations. Just quickly, overview of work. We are, as I said, a global law firm. We've got over 1,200 lawyers in the firm, plus staff, about 2,500 employees. The thing that makes this much more complex for us is we're around the globe, and so we have 25 offices. Probably 65% of our staff and attorneys are in the U.S., 25% in Europe, and 10% in Asia. Hopefully that adds up to 100%. We'll give you that. But a couple of our core strategies are around innovation and to be the best law firm to work for. And so that's why, from our perspective, we think the cloud fits in there, because we think if you look at not only hardware, but kind of the software and applications that are being built today, innovation is really occurring on cloud-based platforms as opposed to on-prem solutions. And we think in terms of mobility, collaboration, other key elements that make our lawyers efficient and make their collaboration better with their clients, we think that's going to lead us to help us meet that other strategy of being the best law firm to work for and hopefully attract the best talent to our law firm. Everybody always asks, what's your cloud strategy? Is it cloud first? Is it cloud last? What kind of cloud equal? So we've gotten to the point now where we're comfortable enough in the cloud that as we make decisions around applications and our infrastructure, when we do that assessment, we're okay to bring cloud providers into that discussion and treat them equally with our on-prem, and kind of made the best business case win as we go through that. And then finally, just to give you an idea of why this is relevant, these are the cloud services that we're currently using. I don't know if you can see those very well, but things like procurement, our IT project management solution. So we started out with things that were really kind of internal to the organization, our own data. We're now kind of moving out into other things. So we're tracking our experience and our client matter information on a platform that's in the cloud. And just recently we made a decision to take our document management system, which is really a core system for law firms. So that's all of our client work product, our client data that we get in that document management system. And we're now in the process of moving that out to a software as a service, cloud-based service provider. And I'll walk you through on my last slide kind of how we went through that decision process, why we chose that, and some of the challenges we faced and things we did good and the answer. So just quickly, kind of, as I said, we've been kind of working on the cloud for at least the last 3 years. We did it for a number of reasons. One, we were pretty much aware that our attorneys were using cloud-based services regardless of whether we had a policy around that or not. They were using Dropbox, they were using Box to share documents with their clients. Our executives were watching TV and hearing about the cloud, right? They were asking questions about the cloud. And then we kind of looked at it strategically and said, from an IT perspective, Doug touched upon some of the benefits, but we really think that, and thought at the time, that the cloud could really give us some benefits around security and compliance. The resources they have, the people they have, are much greater than what I have in my own organization and my own job peril. I wanted people to understand that I think the security out there is much better than what I can provide, regardless of the resources I have. And then finally, we want to, over time, not necessarily reduce staff and save money, but we want to kind of transform our organization from an organization that is spending the majority of our time kind of keeping the lights on, flipping switches, keeping everything operational, to an IT capability that's more transformational and can work with our business to bring value to the organization as opposed to just that maintenance function. So those were the reasons. We, given our global footprint, we spent a lot of time doing research in all of the jurisdictions in which we do work to understand their regulations, to understand their ethical dilemmas, and use that to really build a comprehensive cloud policy almost by jurisdiction and data type to say, as an attorney considering using a cloud for a certain matter, these are the things you need to think about if it's this type of matter, this type of data in this jurisdiction. Again, we didn't put distinct guidelines that you can and can't do this, but we wanted to provide our attorneys with these guidelines to help them through that process. And then we also, as you can imagine, build in some fairly specific things around if we are going to move things to the cloud and select a cloud service provider, what are the things we're going to look for? So obviously, we wanted them to pass a very stringent security review before we agreed to put our data with their service. And to do that, we've created a very substantial set of minimum information security requirements that we used first to really vet out a cloud service provider, and then ask them to agree to those when we negotiate and enter into a cloud agreement with them. We spent a lot of time talking about the contract. We're a firm of lawyers, right? So that's kind of what we do. But really set aside probably between 10 and 20 key contract areas and stipulations that, as we're entering into these agreements with cloud service providers, they had to be built into the contract. Provide a unique service value proposition. As an example, we didn't want to go out and, as a firm, approve OneDrive for Business as a collaboration platform, and then have an attorney come in and say, well, I'd really rather use Dropbox because my client's asking me to do it or that. So we wanted to make sure that there was something in there that said it has to be kind of a unique function over and above what we as a firm are doing today. And then finally, just as with any project, we wanted to make sure that there was going to be a positive return, positive cost-benefit analysis. So as we've been going through this, we've faced a number of compliance challenges. I'm just kind of picking three that I thought might be interesting to you. Obviously, the security of the cloud and putting our data in the cloud. So we've addressed that through, as I said, very stringent security assessments up front, a set of standard requirements around security that we asked our vendors to build into the contract and agree to contractually. And part of that is we've been adamant about our right to either come in and audit the security of a cloud service provider, or to, at a minimum, get a look at their annual assessments, whether it be an ISO assessment, whether it be a NIST assessment, another compliance assessment. Outside council guidelines for us are very interesting. So as we enter into, oh yes, please.
On the assessments, do you find that the vendors will give you their audit reports, or maybe just the executive summaries? How much are they actually willing to share?
That's an interesting, very good question. It depends. We end up negotiating that one. So we go in with the premise that we should be able to see the entire assessment and review that. Depending on the vendor, we've been able to get that. Other times we've had to kind of agree just to look at the management summary, if you will, and maybe some of the key findings of the assessment.
If there was a secret to get to the full thing, because we have that same.
Yeah, no, it's a negotiating point, but at a minimum, we do want to be able to see that they've got that assessment done annually and be able to look at the results and then see if they were sort of recertified, if you will, from an annual perspective.
Thank you.
Yep, great question, though. Outside council guidelines. So when we enter into a new agreement with a client, and even while we're in that agreement, we may get a 50-page document of their expectations of us as a vendor. Traditionally, that's been around billing and travel and things like that, but more and more, they're putting in their own very clear security requirements and even requirements around the use of the cloud. And so for us, it was very important to, as we're receiving those guidelines, getting IT and our security team involved to make sure that we're not agreeing to anything that would go against those guidelines. We also, we're fortunate at the same time, we brought in a new system that allows us to pick pieces out of those guidelines, catalog those, and be able to search those. So if somebody has a question, I have a client, I want to put their data in the cloud, they can very easily kind of search all these guidelines and find out an answer to that question. That's been very helpful. And then kind of thinking about the future, we've started to put in opt-out clauses into our engagement letters. So it allows us to have a conversation with our clients up front. So the opt-out clause is basically saying things like, we as a firm use cloud-based services. We may choose to put your data into the cloud for this engagement. If you, by signing this, you agree that that's not a problem. And very rarely does anybody bring that up, but we have had cases where people have wanted to opt out of that. But in just about every case, we've been able to talk to them about the services we're using, the security, what we've gone through from a compliance perspective, and kind of change that around and get them to sign that. And that'll help us out in the future when we move more and more applications out into the cloud. And then finally, regulatory requirements. Doug talked about the EU. As a global firm, we had to understand the regulatory requirements as much as we could around the globe. And the way we've addressed that, as I talked about, we have developed a matrix by data classification, by jurisdiction, about the considerations you need to think about before putting that into the cloud. We are now using model clauses. We went from the previous regime to the model clauses, and we're already starting to think about the new one coming out next year. But as of now, our approach is to make sure that a cloud service provider, if we're going to be moving data around, agrees to put the model clauses into the contract. And then I guess finally, the one I'll talk about is the geographic location services. I realize this isn't possible with a lot of cloud services, but where possible, we talk to them about where they're going to store our data. If we have a choice, we build that in the contract where we want our data stored and build parameters in there. Typically, it's to at least notify us if they're changing their data center and moving our data storage from one jurisdiction to another, just so we can assess the risk of that and the understanding of that. And finally, it's a very small print here, but we really look to, as we're selecting cloud service providers, look for somebody who's been in the business for a while, who's trusted, who has gone through this security assessment, or if we're looking at a provider that's a relatively new provider, I'm hoping that they're building their product on top of a trusted provider. So as an example, I mentioned we're putting our experience data into the cloud. It's a relatively new vendor, but they built their software on top of Microsoft Azure, which we have already gone through and vetted all the security. So it's very helpful in terms of getting the firm to agree to it, to get through our security assessments and all that, knowing that they've built that product on top of a provider that we've already vetted and approved within the firm. I won't go through all these, but these are some of the key contract considerations that we have identified that we want to build into the contract and negotiate from. A couple important ones I mentioned are information security requirements. Obviously, use of our data, whether it be access to data, whether it be how the service provider uses our metadata, uses our usage patterns, things like that, is all built into that. We're pretty clear in our contract about if, God forbid, there is a breach, how much time they have to notify us, who gets to control the communications out to the public if necessary, and how that whole response approach is going to take place. And then we've talked about the data privacy provisions and data location. And then the last one, obviously, I think obviously, is around system response, availability, and support levels. We spend a lot of time in our contracts really kind of laying out the response we expect and how that matches up to our current benchmarks, how available we expect the system to be, and ways that if the system availability does not meet our specifications, how we can improve that, how if there is just a consistent lack of availability, how we can get out of that contract, and just really working around the SLAs. Quickly on the new ISO certification, the checklist, the benefits, can't tell you how much I wish we had this 3 years ago, right? Because a lot of this we felt like we were trailblazing, right, or figuring out on our own. And it was interesting as I was looking at our contract terms and comparing that to the ISO standard and the checklist, very similar. We hit most of the mark, some things that I learned doing that, but it really would have been great to have that as we were kind of going through this initially, and I think it would have really sped up the process. One thing I'll point out here is the education for newer cloud service providers. We've had at least 2 cases where we've had an on-prem solution with a vendor we really liked. They've moved their product into a cloud model, again, we really liked. But as we sat down with them and started talking about the contract and the agreement, it felt like we were educating them on the things that should be into their initial agreement. We didn't build them for it, but we did feel like we were helping them kind of go through that. But I think this will be really great for those newer folks that are building applications on the cloud to really get a much better starting point and to protect themselves, but also kind of speed up negotiations and really give them a level of credibility that if we hadn't worked with those vendors in the past and hadn't had a level of credibility, I might have walked away just because they hadn't thought about a lot of this from the cloud, and that might have given me an indication maybe they're not the provider I want to go with. And then last, very quickly, kind of wrap this up, but as I mentioned, we have just decided to move our document management system, which was really a big decision for us as a firm to do that. So we assessed a cloud service provider against our existing on-prem DMS and investing further in that. And we did decide to move to the cloud. I'd say the first 2 drivers were the first 2 points there were the main drivers. As I mentioned, we really felt like we were going to get a much higher level of security, a much more complex and safe security model from the cloud service provider. As well, they were already compliant with a number of the standards that we need to be compliant with from our clients. And so we thought over time that would be a better model for us to continue to leverage their compliance as opposed to trying to continue to stay compliant ourselves. Interesting thing, it took us 5 months to select the product and almost as much time to go through the final approval and the negotiations. And some lessons learned from that is, I think it's important to engage your legal officer, risk management, and your privacy experts up front during the selection process. We did that pretty well with our chief legal officer and our risk management partners. We had some cursory discussions with our privacy experts, particularly in Europe. And once we selected the product, those got much more detailed and took a lot more time and a lot more analysis than we expected. Introduce concepts and educate decision makers at the outset. I think one thing we've done well as a firm is we started talking to our management committee and our technology committee about the cloud back probably 3 years ago. The benefits, the risks, all that. And so when we came to them to both assess the cloud for document management and then with our decision, there wasn't a lot of education. It was more about the reasons why, and we'd already kind of gotten them over the curve of being uncomfortable or comfortable with the cloud. SLAs, proof of concept parameters, those kind of things. Again, a lesson we learned was while you're going through selection, really start thinking about what you want in terms of availability, how you're going to measure availability, responsiveness, all of that. Because we didn't really document that and talk to our service provider until we got into contract negotiations. And as you can imagine, lots of back and forth on that one, and that really kind of extended things. So we really should have done that in parallel, and we'll do that in parallel with the selection in the past. And then involve a broad team during the negotiation. So not only do we have procurement, kind of our legal expert, but we have the benefit of having contract experts in lots of different areas. So we had a team across IT, procurement, probably 4 or 5 subject matter experts from other practices within the firm, and members of our cybersecurity team, really kind of working together and getting their input on that. So when we got to the point of signing the contract, I think the firm was very comfortable that we had really addressed things. So bring everybody in early in that contract process. So that's mine. Any questions before I turn it over to Tracy? Any further questions? In the back?
How are you managing access from trainers around the world to the document management? Are you putting it through your own system, or are you allowing them to use the device?
Yeah, so we are actually putting in a WAN connection into the data center where the data is going to be stored. So the majority of our connection is going to be through our own network into the data center. For cases where people do need access remotely, we'll be doing it with dual-factor authentication through directly to the vendor. We're still kind of working through the exact security posture for that infrastructure, but we are going to provide some secure access outside of our own network for cases. But the majority of it will be going through our own network. Yes?
From an implementation standpoint, storing client records or storing highly regulated records in the cloud has requirements that both partners have to meet. So in the privacy world, that might be something like consent,
Right.
Or you're in the healthcare world, access logs. How did you work through those regulatory requirements with the cloud provider?
Yeah, the main things we wanted to understand was their encryption approach and who had access to our data, and also their kind of separation of roles and responsibilities. And then based on that investigation, this is where our EU data privacy folks are very interested as well. We were able to both understand and obtain contractually that they can't really ever see our data in a human readable form unless there's collusion within their company. And so they agreed to that kind of statement contractually, and as well penalties if anything ever occurred. And so our premise is that we're really not turning over client data to them because of those parameters, and therefore things like consent is really not necessary. And that was a lot of discussion, a lot of analysis to get to that point. But absolutely.